Okay, at 11:02, I think I'm going to kick things off. Hello and welcome. Thank you for joining us. This is, again, an additional chapter in our series on fiduciary best practices. And this one is on something that actually happened just a couple of months ago. It actually happened in the flurry of another situation that we're all very familiar with, but this had nothing to do with COVID-19. This was actually a decision by the Department of Labor to issue new regulations regarding the electronic delivery of required participant disclosures. And we're going to discuss that today with my friend from the industry, Allison Fay. She's been practicing for a number of years as an ERISA attorney. She's going to tell us a little bit about herself right now.
Thanks, Scott. Hi, everyone. So glad to be able to participate in this webinar. I want to thank the folks at Northwest Capital for including me. My name is Allison Fay, and I'm an ERISA and employee benefits attorney at Boutwell Fay. Our firm has offices in Newport Beach, California, and also in New York City. Although we have clients in about 40 states, at least over the years we have, our ERISA practice involves federal law, which allows us to practice in almost any state. My particular practice focuses on compliance work for employers, so we try to keep employers out of trouble. We represent employers that are being investigated by the Department of Labor or are subject to an IRS examination. Probably the biggest part of our practice is correction. So that would include self-correction or a voluntary correction program, VCP filings, and also audit a closing agreement program where qualification defects are discovered in the course of an IRS examination. And finally, we advise employers on fiduciary responsibility issues. For example, analyzing potential prohibited transactions and applying exemptions, drafting committee charters, assisting investment consultants with investment policy statements, and also providing fiduciary education for plan fiduciaries. So,
that's great.
Yeah, thanks. Appreciate it. It's interesting because all of us have been, I know, on a gazillion webinars and all, and most of them talk about what to do about COVID-19 and, the CARES Act and all of the things that we've been dealing with. But this is really a piece of helpful guidance, I think. So something that's good.
Yes. I'm so glad in these sometimes all too cynical times that we have something really kind of interesting and positive to talk about. And this is an example of the regulators actually stepping up and making things maybe a little easier for employers to use to comply, but also just a lot easier for them to just implement. So I think we are all very pleased, though, and I just want to say this right at the beginning, that you chose the ERISA area to practice in, Allison, because we really need all the help we can get out here, all sponsor fiduciaries and consultants working with plan sponsors. We need all that guidance that you have just described you provide. So thank you very much for that. So now I would like you to give us a high-level summary of what the new regulation is trying to accomplish.
Sure. So ERISA provides general standards for delivery of ERISA required disclosures. And the general standard that applies is that plan administrators must use methods reasonably calculated to ensure actual receipt of the information. So originally this meant either hand delivery at the workplace or mailing by first-class mail. And then in 2002, the DOL issued regulations that provided a safe harbor for satisfying this general standard for delivery. That is, if you satisfy the requirements of the safe harbor, then you're deemed to have satisfied the general standard for delivery. And under the 2002 safe harbor, which was issued in the form of regulations, it provided for two groups of individuals to whom disclosures are generally made. The first group are those that we call they're wired at work, so meaning participants who use a computer, and it's an integral part of what their employment duties are. And the second group is really everybody else. So generally, that group, the people that fall into this second group are those who don't use a computer at work. For example, like a grocery store, if you have people who are checkers, they're not going to have a computer as part of their work generally. We also have terminated participants and beneficiaries. Terminated participants are not going to have a computer as part of their work. Well, they could, but it's not part of the employer's work. So they would also fall into this second group. So
it's kind of timely, Allison, isn't it kind of timely that we're all kind of working from home now and working on computers, that this is the rule that could have been applied in a lot more general sense, don't you think?
Well, not everyone is actually working, on a computer from home. There are some people who are actually out there, delivering things
doing all
to us.
Yeah. Yes, that's right.
Yeah,
that's right.
so
the brown trucks in our neighborhood and all the
that's right.
workers
Yeah,
that I met on my way to the office today, right?
Yeah.
So, okay, so Allison,
yeah.
Go ahead. I'm sorry.
Well, yeah, I just wanted to say that, so with respect to this second group of employees or non-employed, terminated participants, in the case of that second group, you can make electronic disclosures only after obtaining affirmative consent from that individual and after making some required disclosures. So this affirmative consent requirement, which is part of the 2002 Safe Harbor, is the part of it that's so difficult to satisfy. So employers really have given up on trying to comply with the affirmative consent requirement for that group. At least that's my experience. And generally, they'll just send paper copies to this group to make the disclosures that they're required to make. Now, the new regulation that was just issued provides a way to send electronic disclosures without having to obtain affirmative consent. So it's really designed to satisfy the problem we have with this second group. And while there are requirements that have to be met under the new rule, I expect that many employers are going to use it, and there will be a large reduction for those, especially those who have a lot of paper disclosures that they have to make because they haven't gotten affirmative consent from the second group, and so they'll be able to send notices electronically instead of by paper. So the approach in the new rule is what we call a notice and access approach. So in essence, first of all, the employer is required to send an initial notice, which has to be made on paper, and lets the participant know that in the future, disclosures will be made to your X email address, whatever that is. It has to be, the participant's email address has to be in this notice. And if the employee, and it also lets the employee know, or participant, that if you want to opt out of electronic disclosures and receive paper in the mail instead, you need to let us know. So that's the essence of the initial notice. One of the problems with the initial notice is that you have to put the individual email address of the participant to whom it's directed, so it's going to have to be a customized notice. But nevertheless, you send this out, and then when you need to actually send a notice, a required notice, you need to send what's called a notice of internet access. So this is called an NOIA, a NOIA, to the participant. And then that notice provides a link to an internet website where the document to be disclosed will reside. Now, there were some requirements that have to be satisfied, but if those, for example, I mentioned that the initial notice must be made using paper, but if those requirements under the new rules are met, the employer is deemed to have satisfied the general standards for delivery of disclosures under ERISA.
Okay. And up to this point, so a lot of the employers have been relying on paper, for the people who are not wired at work. And so
That's
there will
right.
there will be a step in there that still has a paper involved, where we're kind of getting this thing set up.
Right.
So presumably the employer has to kind of make best efforts to get the employee's email address, correct?
That's right. There are going to be some new best practices, I think, that employers will want to implement. For example, when they are hired on, you're going to want to get the email address from that person. And you'll want to get possibly backup email addresses in case the one that they give you for the first one isn't good, because I'll explain later on, if you get a bounce back, there's an obligation on the part of the employer to fix that. So find out why it's bouncing back. Is it inaccurate? Is it inoperable? And if you have a backup email address, you can just put that in place because the employee has given it to you.
Gotcha. I can just imagine a situation where you're being hired on, you give them an email address, and then they send an email to that address and to make sure it really works. So this is going to be a little bit interesting, but it seems like once you get that done, then you can kind of be showing that you've satisfied that.
I think there's some work up front, for example, gathering the email addresses, and also, for example, also putting in place your procedures for dealing with bounce backs. Maybe you'll have that delegated to the record keeper. I don't know, but so you'll have to keep a list of those people who do require paper disclosures because they've opted out, or you don't have an email address for them. So there are those issues.
So we were talking earlier, Allison, and you were describing a situation where there was a plan sponsor who I am sure was making best efforts and never going to communicate a blackout notice. Do you want to describe some of the things that happened there?
Yeah. So I was helping an employer with putting together a blackout notice, and we were going back and forth about what the wording of it was, and the deadline that the record keeper had established for actually making this go. The deadline for sending out the blackout notice was coming closer and closer, and we're going, okay, all right, let's send it out. And so the employer says, oh, okay, I'll just send this out by email. And, I said, oh, well, wait a minute. What about your terminated participants? Don't you have to send don't we have to send this notice out on paper? And they go, oh, my gosh. Oh, you're right. So that's a lot of times, if employers are not thinking about it, they can sometimes send out a required plan disclosure electronically without really having gotten either, having thought about everybody who really needs to get this disclosure.
Right. We call these people the forgotten, I think.
Yeah, that's right.
Okay.
Yeah.
So let's get a little bit tutorial here. This is part of a larger framework where the regulators require disclosures. We have a couple of regulators involved, typically the IRS and the Department of Labor. So I think we have a list in the next slide that kind of gives us a little sense of who does what. So why don't we advance to that slide? But Allison, kind of give us a sense of, so what are we talking about here? Who's working on what, and who are the people kind of policing this?
Well, I think you're asking about, and the situation is that you've got, under ERISA, you've got at least two regulators, in actuality 3, because you have the PBGC, but mainly you have the Department of Labor, which I call the DOL, and you've got the IRS. And there are some Department of Labor required notices, and there are some IRS required notices. And so you have to know which one you're talking about in order to figure out how you're going to send out the notice, because the rules regarding IRS required notices are somewhat more liberal. They're easier to satisfy. You don't have the affirmative consent requirement that you would have with sending out a DOL required notice. To make it even more complicated, you've got some notices that fall in both categories. So they're both a DOL required notice and an IRS required notice. So that's, for example, what we call a 204H notice, where you've got a reduction in benefits. So you really need to know which type of, who's requiring the notice. One thing I did want to make a few points about, I want to go back just for a minute, Scott, and explain that the new reg does not apply to IRS required notices. So for a safe harbor notice, there is no, you cannot, at least at this point, you cannot use this new regulation to make, for example, a 401k safe harbor notice. Now, the IRS has said that they're going to be issuing guidance on this subject, and so it may be that they will come back and say, yes, if you send out notices and it complies with the new DOL regulation, then we're saying it is deemed to comply with the IRS rules too. And that's, I think, very likely to happen. I want to make a few points about the new regulation before we move on real quickly. And first, I wanted everybody to understand that the new regulation is really entirely voluntary. So employers don't need to implement the rule. The 2002 safe harbor is still available, so you can decide, okay, we're going to keep doing things the way we are. We're going to use the 2002 safe harbor, and we're going to continue to distribute paper to the people who are not wired at work, who are not wired at work. Also, you need to understand that the new regulation only applies to retirement plan disclosures. So it doesn't apply to welfare plans, for example, health plan disclosures like COBRA notices. You can't use these rules for those types of disclosures.
Gotcha.
Also, the new regulation does not apply to disclosures that are required only when a participant makes a request for the document. So, for example, under ERISA, a participant's entitled to receive a plan document, but only if he or she requests it. So, in this situation, you're not able to use this regulation for those types of documents that a participant may obtain upon request.
I see.
So
it would not satisfy. Yeah. So if I just was going to ask it. So I've had people say, can I get a plan document, participants I'm talking with. And I said, sure, you're right. So if they were to affirmatively request that from their employer, the employer would not be able to rely on electronic delivery, or would they have to ask the participant? Well,
possibly.
If that's
you might be able to use, you could use the 2002 safe harbor. So if, for example, it's an employee, you could send them the document to an email and rely on that.
Okay, because you have a reasonably good expectation that email still works and all that.
Yeah.
Okay. So it could work, but that's not the way you typically have to satisfy a request like that if a participant comes at you for something specific. Is that right?
Right. Yeah.
Okay. So it seems a little bit like, and this is kind of a little bit ironic to me, the IRS is a little bit more liberal in its approach to how their regulations have to be satisfied. So the DOL is a little bit more specific and perhaps a little bit more stringent. But overall, oftentimes plan sponsors are relying on others to actually satisfy. You mentioned vendors or record keepers or someone else who's actually doing this. So who's doing what, I guess, is the good question in your experience.
Sure. Well, for DOL required notices is generally the plan administrator who's responsible for providing these disclosures. And I just want to make sure everybody understands what I mean by the plan administrator. So plan administrator under ERISA is a technical term. It's not just the third-party administration firm that you may have hired to comply, with all these bring the plan into compliance. No, most of the time, those TPAs or record keepers are not going to take on the role of plan administrator. They don't want that legal liability. So they will, by contract, agree to do certain things for the employer as the plan administrator, but ultimately, whoever the plan administrator is going to be responsible. Now, under ERISA, the plan administrator, by default, is the employer unless the employer appoints somebody else to be the plan administrator. For example, you might have a committee of individuals who serve as the plan administrator. I don't generally recommend that you do that because then those people who are appointed to be the plan administrator could be liable for various penalties that might apply. One of the examples I gave you, Scott, earlier is the filing of a late filing of a 5500. There's some significant penalties that apply in the case where you file late, and especially if you don't correct it. So those individuals who are serving as plan administrators could be personally liable for those. Now, I want to distinguish the situation where the employer actually appoints an individual or group of individuals to serve as plan administrator versus the delegation of plan administrator duties to that group of people. That's different. And that's what I do recommend, is that you have a committee serve to, to oversee the responsibilities that the plan administrator has. So anyway, do you have any other questions about that, Scott? Did I make that clear enough?
Yeah, well, I'm just thinking about some of the practical applications. So in dealing with vendors, they have something they always refer to. Well, you have to take a look at our service agreement. That's what we've agreed to do.
That's right.
So you have to get in there and say, okay, it says here you'll handle all disclosures. So, let's get into some details on that. Are you going to handle that? Does that mean that you're taking on the role of plan administrator? I can just imagine the debate that sometimes gets missed. They're saying they'll do stuff, but they're not really responsible for it. Now, is that
right?
Am I reading that right?
Absolutely. A lot of times plan record keepers will say, right, we'll do everything for you. But then when you actually read the contract that they've, have you sign, and a lot of employers will just sign these record keeper service agreements without really reading them. But I would suggest that the best thing you should do, especially if you're trying to implement this new rule, is look at your service contract that you have with the record keeper, and see what it says about disclosures. Who is responsible for providing QDIA notices, for example? Sometimes the employer has that responsibility, and the record keeper isn't going to take that on. So if that's the case, you need to know that as a plan fiduciary, because if you're on a committee where the committee is responsible for making sure plan administrator duties get accomplished, then you want to make sure that the QDIA notices go out and that they go out in the way that they're supposed to. So absolutely, you want to know what that service agreement says, and if the vendor, the record keeper, hasn't taken on a responsibility that exists out there, there's a notice that has to go out, then the employer has to figure out how they're going to get it done internally.
Okay, so we are fortunate enough to have some folks delivering some questions to us. And so in one case, I have a question that seems to be relevant to what we're talking about right now. Are there any documents that specifically cannot be delivered electronically?
Well, let me think about that. Well, we gave really one example is that this new regulation, this new safe harbor, does not apply to documents that are provided upon request of the employee or participant.
Got it.
So that's one example, like plan documents. Now, like I said, you may be able to rely on the 2002 safe harbor to provide it electronically, but if you're talking about one of the forgotten, so to speak, one of the people who are not wired at work, then you would have to provide it on paper.
Got it. Okay. So there are going to be examples where it's customary to deliver a paper document regardless of this new rule.
Well, yeah, it's really, it's more like groups of people who are not going to be able to receive documents electronically.
Yeah, the forgotten ones we were talking about.
Exactly.
Yeah. And I did want to let everyone know that we will be providing the slide deck, the presentation to everyone who has participated today. So you don't have to be scribbling down all those notes that you're busily taking right now. So I was going to go into a little bit of depth about this idea of the record keeper and its service agreement, because I don't want to leave the plan sponsors in our audience with the idea that we're somehow, trying to point fingers at the record keeper or the vendor. They actually are relying on guidance. And I think, Allison, you mentioned something called field assistance bulletins, where the regulators actually understand something about this. So can you kind of describe that a little bit?
Yeah, well, there are at least three areas, three pieces of guidance that have been issued by the Department of Labor, and those are what we call sub-regulatory guidance. And these three pieces of sub-regulatory guidance are going to be superseded by the new regulation. So in essence, you can't rely on them anymore. And what I mean by sub-regulatory guidance is that the guidance issued by the DOL has not gone through the process of becoming a formal regulation. And those can be in the form of a field assistance bulletin, which Scott asked about. So there's a couple of those. And then there's another technical release that the DOL issued back in 2011. So let me just talk about those very quickly. Okay. So, and let me just say that fortunately the DOL has provided a transition period so that employers and record keepers can have time to change their systems. And that transition period is going to start at the effective date of the regulation, which is July 27th, and it'll run for 18 months. So let's talk about what these three pieces of guidance are. Well, first is Field Assistance Bulletin 2006-03, which relates to the provision of quarterly participant statements. So, back in 2006, I think it was PPA established that you had to have these quarterly participant statements, and as a result, the DOL came out and said, yeah, we got it. This is going to be hard to do, so we're going to give you a break, and you can use the IRS electronic disclosure rules for providing these statements, and you can also use a continuous access website. So there are those rules are, as I've mentioned before, are much more liberal than even the new regulation. So when that goes away, that field assistance bulletin, you're no longer entitled to rely on it. You're going to, record keepers are going to have to do this in a different way. They're going to have to comply with either the new regulation or start using paper or rely on the 2002 safe harbor. Anyway, they're going to have to do something about that. Just the couple of other release pieces of guidance are Field Assistance Bulletin 2008-03, which allowed QDIA notices to be distributed using the IRS electronic disclosure rules. And then finally, Technical Release 2011-03R, which allowed for electronic disclosure using a special rule that was similar to the new rule, but not exactly the same, allowed you to distribute 404A5 participant disclosures electronically. So
that's the one that's the fee disclosure one.
That's the fee disclosure, right? Exactly.
Okay.
And so yeah, way back when in 2011, the record keepers and all were going, how are we going to get this done? So the DOL at that time gave some guidance that remarkably is similar to the new regulation, but not the same. So because plan administrators, your committee, you're going to need to make sure that your record keeper, okay, you guys changing your system because, hey, you know, this guidance is going away in 18 months. So anyway, you need to figure that out. They need to figure it out. And you, as a plan fiduciary, if that's your role, you need to make sure that they have actually changed their systems.
Right. But that's our job, to kind of keep people informed of how they can best comply. So I have an interesting question, sort of turning things on their head a little bit. I think we should advance the slide, because what we're talking about is prudent process here. How do I go about complying? Obviously, I know that there are rules. I want to comply. I'm trying to figure out who's going to do what. I'm going to get this all kind of written down somewhere. But I have a plan sponsor who's asked, instead of keeping a list of all those who have affirmatively requested paper. So again, the rule is that you can rely on electronic distribution as the default process. And then the participant can always opt to, no, I would rather have paper. So it's sort of like the inverse of what we get when every one of our financial institutions says, oh, go paperless. You actually have to say, yes, make me paperless. In this case, the paperless is in front of the paper. So this person is asking, instead of keeping a list of all those who want paper, could we just always send out the electronic notice to everyone and then make someone come back each and every time to declare, no, I want this in paper? So in other words, we're satisfying it with the electronic, and then they have this affirmative, like an iterative request for paper. Do you think that would fly?
I don't think so. I don't think so. Because the idea is that you're sending out this initial notice where you're telling everybody we're going to do electronic disclosure, and here's your right to opt out now. But if you opt out, if a participant's opted out and you're not honoring that opt out, that's a problem. Yeah, I don't think you can do that.
Okay, so once they've established themselves as I want paper, I get paper until I say stop.
That's right.
Essentially.
Yeah.
Yeah,
now you could go back to them. You could go back to them and say, don't you want to sign up for electronic disclosure? If so, I need your email address, and you send them another initial notice. And then if they don't opt out of that, then I think you're good.
Yeah, we're invited often to become paperless. Like pretty much every time I sign into some of my banking websites. Oh, yes, okay. So we have some big ramifications if we don't handle this. We obviously have an affirmative requirement that our plan sponsors figure out who's responsible for what. The plan administrator is that key role that needs to be identified, and by default it ends up being the company. So we want to make sure that's clear. But there's some things going on now that I think are actually hitting the courts. And there's one Supreme Court case that's not exactly on this subject, but it is somewhat relevant, involving disclosures, I think. Can you kind of take us through that a little bit?
Sure. There was a recent U.S. Supreme Court case by the name of Intel versus Sulema. That's how I pronounce it. I apologize if that's not the right pronunciation. It's relevant, definitely, and just decided in May, same month as the issuance of the regulations. Interestingly, there's a reference to this case in the regulations. But anyway, the issue in the case was whether ERISA's 3-year statute of limitations or the 6-year statute of limitations applied in this particular case. So just a little bit of background. Under ERISA, as I mentioned, there are 2 statutes of limitation. One is a 3-year statute, which applies when the plaintiff in the case has actual knowledge of the breach. And otherwise, there's the 6-year statute of limitations applies. Now, there might not be a statute of limitations if you've got fraud, but generally you've got these 2 statute of limitations, either a 3 or a 6-year. So in this case, which was a class action, was brought by Mr. Sulema, who was an Intel employee, and he was a participant in the Intel 401k plan. His account was invested in a target date fund. And the plaintiff, Mr. Sulema, alleged that the plan fiduciaries had overinvested the target date funds in hedge funds and private equity. So the trial court in the case held that because Mr. Sulema had actual knowledge of the suspect investments 3 years before bringing the lawsuit, the statute of limitations barred him from bringing the case. And on appeal to the Ninth Circuit, the Intel argued that Mr. Sulema had actual notice of the investments because Intel had provided all these electronic disclosures to him in the form of a QDIA notice, an SPD, and various other documents that revealed that the TDFs were invested in hedge funds and private equity. So the Ninth Circuit reversed the trial court, saying that actual knowledge means that the plaintiff is actually aware of the facts constituting the breach, not merely that those facts were available to the plaintiff. So, and the Supreme Court agreed with the Ninth Circuit that there has to be, actual knowledge, and that in order to for a defendant to rely on a 3-year statute of limitations. So in light of this case, some employers are attempting to implement, like a process where the participant would have to acknowledge that he or she has received and understood this disclosure. Well, I don't exactly understand how you could get that from everybody, because there obviously some people are not going to do that. But as an alternative, they might want to, an employer might want to investigate ways to track when a participant has actually accessed an electronic disclosure. So when they've opened it up. So if they have, then, you have some evidence that they had actual knowledge. And so that might help you to get beyond like a summary judgment motion or something like that, So
Gotcha.
Anyway.
Yeah. So pretty sophisticated tracking of people sort of having, acknowledged receipt by opening.
Right. Yeah. It wouldn't be such a bad idea. It could be costly. I don't know. That's something it's not in my wheelhouse. But it would be interesting to know, I think, from an employer standpoint, to know how engaged participants are. Do they really open these things and look at them or not? Yeah.
Okay. Well, it'd probably be a good practice anyway. If we're going through the whole figuring out whether we have good email addresses, it's probably part and parcel of that. It's sort of an IT process to assure a certain level of confidence that we're getting important information to our folks. Again, this is not about getting sued. This is about fulfilling so you don't get sued, I guess.
Exactly.
Okay. So I think that what we really want to make sure that everyone is aware of is that this falls under this prudent process area of committee best practices. We've hit on several of these. We have the list right there on the slide. Determine who is responsible for what is one of those that sometimes gets set aside a little bit, but really it's about this whole assumptions hurt all of us. Let's make sure we get everything clearly spelled out as far as respective responsibilities. I know that that's something we're making sure that we put into investment policy statements now. There's another area that some of my plan consultant colleagues would emphasize, which was make sure that you comply with ERISA and your documents. And I think you clarified this a little bit for me. It's comply with your plan document to the extent it conforms to ERISA. So in other words, if the plan document and ERISA are at odds for some reason, it's not updated or something. So in other words, ERISA still controls. Is that right?
That's right. If your plan document says that you can do something that's not permitted under ERISA, then you still can't do it, even though the plan document says it.
Just because I said I passed go and I'm still not going to get my $200. Okay, and then the last one, I think I'd like to have you hit this one a little bit, because it seems like prohibited transactions would be a hard one to commit, but I think I might be oversimplifying that. Can you give us some examples of prohibited transactions that you've been had encountered in your practice?
Well, I think the one that probably gets violated the most is, perhaps anyway. Well, keep in mind that prohibited transactions come into play when, for example, you have late contributions to a plan. So when you have a late contribution to a plan, that's technically a prohibited transaction. And you have to file an excise tax return when that happens. There are some ways to get out of that. Another example is
so let me just, that's a prohibited non-transaction. That's another, you failed to send the money in. So
well,
okay,
the way the DOLs use this is it's like a loan from the plan to the company, because that money should have been in the plan earlier. Okay, the plan's loaning you money. That's a related party transaction.
I gotcha. Huh.
Yeah, that's how they view it. Yeah. So here's another one that comes into play that kind of goes back to your monitoring fees bullet point there, and that is when you pay an unreasonable fee to a service provider, that's a prohibited transaction.
Okay. Okay.
Yeah.
So you can violate on multiple points of this list here.
Exactly. They're all kind of connected. Yeah.
Yeah, it's exciting to be a plan fiduciary, isn't it? So I'm going to, that pretty much brings us to the end of our prepared remarks. We do have a slide here that we go into a little bit of sort of where are the pitfalls, and I call it, what is the source of most regulatory issues that you've encountered? Can you give us kind of a sense, when does the DOL show up? Is it random? What triggers a DOL audit? Right.
So my understanding, and this is what I've heard directly from the DOL, is that there's no such thing as a sort of regular audit by the DOL. Every investigation by the DOL is on account of something that's causing the DOL to want to look into it. That can be something that you've put on your 5500, like I didn't get a bond, or I didn't correct my late contributions, something like that, or I'm invested in real estate. That's a big one. But a lot of times you'll have participants who call up the IRS and complain. And there's a whole group of people at the Department of Labor who, and I think they call them benefit analysts or something like that, and they take the calls of participants. And if you, as the employer, don't respond, for example, one of these benefit analysts comes back to the employer and says, hey, you're harming this participant by this way. You haven't given him a copy of the SPD, for example. Then you better respond, and you should do it in a way that, makes the DOL feel warm and fuzzy about your compliance. Because if you don't, the potential is there for a full-blown DOL investigation. You do not want that, because, they start out by sending you a 3 or 4 page list of documents that you have to provide, many of which employers have no idea what these are. Okay, what is that? What do I have to? Anyway.
Where would I find that?
You don't want to go there. Yeah.
Yeah. Sounds like that. I'm seeing dollar signs when I get one of those letters, huh? Yeah.
Right. Right.
But in my practice now, I did encounter a circumstance where I was working with a committee. I was actually a subject matter expert, so I didn't work with them regularly. But they had been dealing with something, and it came up during the meeting where there was clearly a participant who was couching the way they wrote these letters as if they were on the way to a lawsuit, and the legal counsel was sort of reading this and saying, this is not the typical way typical people write letters. This looks a lot more like one of my colleagues, a lawyer, is helping write this letter. So there are some folks who do that, but by and large, these are legitimate issues, right? Participants feel like they were supposed to have gotten notice of something, or they're supposed to get some money in a timely fashion, and they didn't. So what you're basically saying is that ever happens, and you get notice that somebody's complaining, they don't go to the DOL first, right? They come to the company usually, right? Oh, sure, yeah. And I think the DOL would tell them to do that. If they need a copy of the SPD, well, you got to go to the employer first. Yeah. Have you tried to get it? And then when the employer is just sort of ignoring them, and again, we want to try and couch this appropriately. I don't think any employer intentionally ignores a request. They just get sort of sidelined. They get on a pile somewhere, and
absolutely.
people just don't respond. Yeah, okay. So
yeah,
it can be an inadvertent thing.
HR people are notoriously overloaded with work. They have so many things to do, and like retirement plans is just a small fraction of what they generally are responsible for. You've got health and welfare plans that are even worse. So.
we don't have time to go there.
No, we don't.
But there you have it, HR members of the audience. You have an advocate who just announced that you're overworked, and she's on your side. So I'm going to ask one more time if we have any more questions from the audience. We had 3 good ones there in the early going. I'll remind everyone this is just part of our ongoing series. About every other month, we'll have a fiduciary best practice presentation like this. I want to thank Allison, not neglect to thank her first and foremost for the wonderful insights you provided today. It's just more things than I could ever have possibly thought of that you've brought forward here. If you would advance to the last slide there, we have some contact information for Allison. Allison, I believe you're making offer of your newsletter so that you can keep people current. And it's just a developing field. When we were preparing this presentation, it just seemed to me like one of these interesting things that the DOL was hoping to get some real positive feedback on this electronic disclosure, but we were having a kind of a distracting event in our national lives that sort of snowed right over the messaging. So I'm glad we're getting this out there, or getting this information. This actually is an example of the regulators responding to a need, helping employers comply better with the rules. And are there any final words you'd like to say, Allison, to our audience?
Well, I did want to just add one point on the whether or not employers want to just jump on this right away and try to comply with this regulation or use this new way of providing electronic disclosures. And I wanted to point out that the DOL has issued some relief in light of the COVID-19 emergency, and they issued this not just a few weeks ago and said that if a planned fiduciary fails to provide a required notice that had to be furnished between March 1st, 2020, and 60 days after the end of the emergency, then the fiduciaries will not be in violation of ERISA if the fiduciary acts in good faith and provides the notice as soon as administratively practicable. And good faith for this purpose includes use of electronic means. So, so if so you might want to take advantage of the COVID-19 relief, at least until it's over. You don't need to actually jump on this right away, because that relief is much more easy to satisfy than the new regulation. But in the meantime, you can start, collecting your email addresses for all of your non-wired at work participants and getting your systems together so that when it's time, you'll be ready.
Yeah, and we already mentioned that the vendors are going to have an 18-month period to spool up on this as well. So I think everybody's being very reasonable about this, particularly in light of the current national emergency with the health crisis. Again, Allison, just wonderful having a conversation with you today. I look forward to our next opportunity to get some more insights on some interesting best practice ideas. I want to thank everyone who participated in the session today. And you can send us an email to either of our organizations with any questions that come up, later on. We'd be glad to entertain them. And again, the slideshow will be available to all participants, and you will be able to get a recorded copy of our webcast today on our website. Thank you very much.